afternoon, Your Honor. My name is Robert Gleadall, and I'm here on behalf of the appellant, MOLSON Canadian versus the respondent, Douglas Black. In my submission today, Your Honor, I would like to bring attention to the fact of how the Superior Court of Ontario had overstepped their power in this case concerning the authority of the National Arbitration Forum, which is the NAF. This all started, Your Honor, when the self-employed website developer, Mr. Black, decided to register his domain name as Canadian.biz. At that time, MOLSON Canadian already had rights to the domain name MOLSONCanadian.biz, and because of that, Your Honor, a conflict developed between the two entities. The respondent received this domain name through a public auction from two different companies by the names of New Level Inc. and For Domain. On April 10th, 2002, Your Honor, the respondent was contacted by a representative from MOLSON Canadian and explained to the respondent that they owned the trademark for the word Canadian and demanded that he transfer the domain name to them. The respondent then mentioned that there were many companies using the word Canadian in their domain name. Shortly after, Your Honor, MOLSON had emailed the respondent mentioning that they appreciated that Black didn't have any intention of creating negative publicity or confusion, but that the respondent couldn't guarantee that he wouldn't change his mind in the future, and that the future owners wouldn't also do the same. Well, Your Honor, this last statement obviously gave some concern to the appellant, and this motivated MOLSON Canadian to initiate a complaint with the NAF against the respondent. The National Arbitration Forum, Your Honor, is a dispute resolution service provider accredited by the ICANN. In other words, Your Honor, this dispute would be heard under the Startup Trademark Opposition Policy, which is called STOP, which is also the dispute policy adopted by the ICANN. Even though their scope is very narrow by nature, Your Honor, this authority is one of the most knowledgeable and skilled in the discipline of Internet law concerning domain names in Canada, and is the only authority capable of arbitrating matters of this sort for the appellant and the respondent. In addition to this, Your Honor, the National Arbitration Forum panel consists of one previous justice to adjudicate this dispute, and the remaining being all lawyers in the study of law pertaining to the Internet and domain names. Both the appellant and the respondent at this time agreed to be bound by this contract and to subject themselves to the judgments handed down on this matter. Both the appellant and the respondent had the option, as provided by the policy, to either commence judicial proceedings to resolve their dispute or transfer it to the courts during the disputes resolution proceeding. However, both the appellant and the respondent agreed to be heard by the NAF at that time. At the conclusion of this tribunal, Your Honor, the judgment was in favor of MOLSON Canadian, and the respondent was ordered to turn this name over to the appellant. When the judgment from the NAF was not in favor for the respondent, Mr. Black then sought out the Superior Court of Ontario for satisfaction. Your Honor, this is where the problem begins. In effect, the Superior Court of Ontario made an outright collateral attack on the findings of the NAF by ignoring what they had to say on this matter. Had our client broken a law, Your Honor, then the Superior Court of Ontario could make a ruling on that subject, but no laws were broken. However, the Chief Justice felt that he was more enlightened than the panel from the NAF tribunal that both parties were in contract with, and they took absolutely no note and gave no consideration to the authority to the decisions from the NAF. This, Your Honor, is where we feel that the Chief Justice had faltered in this case. The de novo hearing from the Superior Court of Ontario took this stand, Your Honor, and failed to consider the panel's decisions from the NAF, wiping clean everything from the tribunal and reversing the tribunal's decision and passing the name back to the respondent. The final decision from the NAF, Your Honor, confirmed that an issue estoppel is needing to be honored, and my client needs to be made whole again by overturning the previous judgment from the Superior Court of Ontario's decision on this matter. For this reason, Your Honor, we are pleading for an appeal on this issue. In addition to this, Your Honor, please consider that the Canadian company referred to as MOLSON has been a part of the Canadian fabric since 1786, second only to Hudson Bay Company. For these last 200 plus years, Your Honor, they have contributed literally billions of dollars to building the brand name of the MOLSON brand, whereas Mr. Black has very little to lose on this subject, as he is only just at the starting point of his small company. To conclude, Your Honor, we feel that there has been an injustice toward the appellant passed down from the Superior Court of Ontario. The National Arbitration Forum was the tribunal with the needed level of expertise in this narrow scope, whereby an issue estoppel was confirmed. In addition to this, Your Honor, it appears that there has been a collateral attack against the authority and decisions of the NAF. Unfortunately, Your Honor, the court gave no reasons for exercising its equitable jurisdiction the way it did. Finally, Your Honor, did the Superior Court of Ontario have the authority to negate the contract between the NAF, the appellant, and the respondent?